If you are going to lend money, you need to know how to mitigate the catastrophic damages of your borrower filing for bankruptcy protection. How do you do this? By securing your promissory notes. Buckle up because we're going to cover all this and much more. Hi, I'm William Dolan, and this is Esquire Advice, where we explain complicated and lucrative real estate and business topics. Remember, we are not forming a lawyer-client relationship by way of this channel. Always consult your local attorney before taking any action. With that said, grab a pencil and a piece of paper and get ready to learn. Welcome to our episode on securing promissory notes with a special emphasis on real estate transactions. However, before we dive in, please kindly hit those like and subscribe buttons so we can keep bringing you valuable and profitable content. We're going to tackle this subject key concept style. The first key concept is promissory note fundamentals. There are many minimum requirements to make a note enforceable, and if you are the lender, there are certain provisions you want to be sure are included to protect your interests. There are some limitations to what you can do or charge as a lender, and some situations that may require you to obtain a lending license and/or adhere to consumer protection laws. However, we have an entire episode devoted to those topics, so I will direct you to that episode to get all of the information you need there. The second key concept is understanding what it means to secure a promissory note. A promissory note by itself is just a financial obligation. If a lender wants to secure repayment of the note, it first needs to identify the type of collateral. The most common way to secure a promissory note is with real estate. How do you do that? And the associated benefits and procedures can vary from state to state. For example, some states are mortgage states where a lender must go through a judicial foreclosure process. That means it must foreclose through the courts. Some states are deed of trust states, where a trustee is appointed in the deed of trust document. A deed of trust conveys a power of sale to the trustee, which grants the trustee the right to sell the property in a private sale. By private, I mean it is not going through the courts. As you can imagine, there is a lot of legal language that needs to be included in a mortgage or deed of trust. Sometimes a lender may also want a lien on other rights associated with the real estate, like the right to collect rents upon a default. That is effected with an assignment of rents document. If the loan is a short-term loan like a fix and flip type of transaction, the lender may want the right to step into the borrower's shoes and take over agreements with contractors. That is typically effected through an assignment of agreements document. A lender can also obtain a lien on stock or LLC interests. These kinds of liens are generally effected with a pledge agreement, possession of the stock or LLC certificate if the interests are certificated, and the filing of a UCC-1 form with the applicable Secretary of State or other appropriate state agency. If the borrower defaults, the lender can conduct a sale similar to a power of sale with a deed of trust on the stock or LLC interests. Also, the sale must be performed in a commercially reasonable manner. Using stock or LLC interests as collateral can be very tricky to navigate, so you definitely want to use an attorney to help you with the applicable due diligence and document drafting. For instance, if there are LLC interests, most likely the LLC has to opt the LLC interests into Article 8 of the UCC, which requires an amendment to the LLC's governing instrument. To amend the LLC's governing instrument requires a legal analysis of the company's operating agreement or governing instrument to make sure that the proper people have authorized the amendment and that it gets properly executed. The LLC or corporation likely needs to consent to the pledge as well. The entity should also be in good standing. However, please note that was not an exhaustive list of issues that can come up when you are securing your note with LLC interests or stock. A lender can also obtain a lien on motor vehicles and other personal property. The third key concept is power and authority. If the borrower is an entity, you want to be sure that the party signing on behalf of the company has the power and authority and is authorized, empowered, and directed to execute and deliver the loan documents at closing. This will require a legal analysis of the company's organizational documents. I cannot tell you how many times I have reviewed LLC agreements and discovered that there is a person listed in the LLC agreement as the manager or member of the LLC that is not involved at all in obtaining the loan with my lender client and that the lender knows nothing about. Usually in these situations, these people are no longer involved with the LLC, but they have never been formally removed, which could become a huge problem later. If you have an attorney represent you as lender, the attorney should handle identifying these issues and explain what needs to be done. The fourth key concept is title insurance. This is only applicable if you are securing your note with real estate, but you should have the borrower provide a lender's title insurance policy. I would also recommend having your attorney review the title commitment so that he or she can make sure that the exceptions that can be removed are removed, which sometimes requires the attorney to request one or more riders be added to the policy. This policy of insurance protects your lien position in the property, subject to a very limited number of items. The fifth key concept is bankruptcy and insolvency issues. These are the primary reasons that a lender generally wants to have collateral to secure a note. If there is no collateral, the lender is an unsecured creditor. Unsecured creditors generally get little to nothing in bankruptcy and insolvency proceedings. However, for instance, if the lender has a mortgage against a piece of real estate, even if the borrower files for protection under the bankruptcy code, the lender's loan is still secured to the extent of the value of the real estate. And the lender will eventually be able to foreclose against the property to satisfy the note once the automatic stay is lifted or the case is discharged or dismissed. Before I move on, I want to address one more point. Provisions that state a party is still on the hook for the debt, even if the debt is discharged in bankruptcy, are unenforceable because they are against public policy. Just think about it. If it were that simple, every lender would include this provision in its promissory note and no debt would ever be dischargeable in bankruptcy. The sixth key concept is personal guarantees. You effect a personal guarantee with a guarantee agreement or a guarantee and suretyship agreement. As with other documents we have discussed here, there are many important legal issues like consideration, legal fees, confession of judgment, borrower bankruptcy, and others that you need to navigate. So please be sure to work with your attorney on your guarantee agreements. When the borrower is an entity, or if the borrower is an individual and has income, asset, or credit issues, it's useful to get a party with a strong balance sheet to guarantee repayment of the note. What do I mean by balance sheet? Lots of assets that have equity in them, and particularly ones that a creditor could get to if it had to collect against the guarantor. Business assets, equity in real estate, cash assets, and the like are generally good ones. Money in retirement accounts is very difficult to get to. You should always want to do a thorough analysis of the assets of guarantors and discuss with an attorney how easy it may be or may not be to get to those assets. Otherwise, you do not know how strong the guarantee really is. Having a guarantor is also helpful when the borrower becomes insolvent or has a debt discharged in bankruptcy, because if the note and guarantee document are drafted properly, the guarantor should still be on the hook and you have another collection avenue. Now, I know what some of you are thinking, but Bill, didn't you just say that you cannot make a party liable for a debt if it's discharged in bankruptcy? What I said was that you cannot make the party who had the debt discharged in bankruptcy remain liable for that debt. So if the borrower filed for bankruptcy protection, but the guarantor did not, you can still go after the guarantor. Now, if the borrower and guarantor both have the debt discharged in bankruptcy, you can only collect against the collateral if you had the loan secured by collateral. Again, by collateral, we're talking about the real estate, stock or LLC interests, motor vehicles, and the like. The seventh key concept is that customarily borrowers pay for all of the lender's costs, including document preparation, attorney's fees, recording fees, and title expenses. So don't be afraid to tell your borrowers that you are going to use an attorney, the borrower will have to pay for that service and your other costs, and that you're going to do this the right way. Finally, there are many other issues with lending money like usury laws, consumer protection laws, licensing requirements, and many others that you should discuss with your attorney when you lend money. We've covered these issues in our episode on promissory notes, so check that episode out. I hope you found this episode on securing promissory notes helpful. Please kindly hit those like and subscribe buttons so we can keep bringing you valuable and profitable content. Thanks for watching, and I'll see you next time.